Welcome back. Today we'll be covering history of law and development and the ADM, Analytical Law and Development Model. Since the 1950s, there have been three distinctive moments or movements in law and development. In the 50s and 60s, a group of lawyers and scholars, primarily from the United States, tried to transplant U.S. legal practices and methods of legal education at U.S. law schools in the developing world, with hopes to facilitate development through effective legal apparatus. So the idea was that in order to develop the third world, the modern law from advanced countries would have to be adopted so that it can promote the diffusion of capital and institutions and values from the first world. And scholars such as Walt Rostand promoted this idea of modernization. So the law at the time was considered to be a force which can be molded and manipulated to alter human behavior and achieve development. By the 70s, however, these efforts were considered to be a failure. What are the causes of failure? These efforts fail to understand the local context and local needs. As you may remember from our discussion in the general theory of law and development, in order for a law to be effective, you have to have a good organization of LFIs, and those laws should be adapted to local socioeconomic conditions. You might recall that. If the law is not adaptable to the local socioeconomic conditions, the law is not effective. And here, the different socioeconomic conditions on the ground were not considered, and the law could not be effective without such consideration adjustments. In the 80s and 90s, the rule of law projects revived, and the idea then was to focus on deregulation and privatization. So there were efforts to use the law, again, from developed countries, to promote deregulation and privatization in the developing world, and the results were not always successful. These efforts did not lead to economic improvement for most countries, including Africa, Latin America, and Eastern Europe. And scholars found the common causes of failure. Again, these efforts did not successfully implement in the context of local socioeconomic conditions. In many of those places, few institutional capacities, such as the legislature and judiciary and administration, were not present, and without due institutional support, laws alone could not be effective. However, such laws may emphasize deregulation and privatization. Also, if you look at the actual development history, successful developing countries in the past, such as South Korea, Taiwan, and Singapore, the policies were not focusing on deregulation and privatization. In fact, as we saw, these countries used strong state-led policies for industrial development. So policy direction may not have been always successful in the context of developing countries, and also the effectiveness of these laws could not be secured where these laws may not have been adapted to the local socioeconomic conditions without strong institutional support. So in the 90s, late 90s, these approaches transplanting advanced laws from developing countries met revision. So many scholars and practitioners thought that merely transplanting laws from advanced countries may not be effective in the context of developing countries. So some try to expand the notion of development. So from the focus on economic development in the 90s and afterwards, some scholars have expanded the notion of development beyond the economic issues. So leading scholars such as Amartya Sen promoted development as freedom, focusing on non-economic development issues as well. And then some rejected neoliberal approach. As we have discussed, if you look at history of development, some of the most successful countries did not adopt the neoliberal approach, at least in the beginning of their development stages. So there has been rediscussion of the adequacy of focusing on neoliberal ideas. And then also some others have promoted the importance of institutions. Institutions refers to a wide range of organizations and norms and practices related to adoption and implementation and enforcement of law. So these institutional support is also important for the successful implementation of law. Scholars have pointed out the mismatch between the assumptions on the nature and role of law, its relationship to social change, and the role of certain institutions and realities on the ground. So law may not represent ideal universal values. It's often a compromise among the powers, and it's not always that the law promotes the well-being of the majority. So realities of law need to be better understood, and this has affected the presumptions that we have about the law when we try and implement the law in society. So the same mistakes repeated in the first and second moments, in the sense that the policymakers focused on the ideals of laws, and they may have disregarded the important socioeconomic conditions on the ground and the mismatch I've just mentioned. So Joe Merriman has pointed out that there is no strong theoretical basis for this movement. Direct transplantation of American legislation didn't have much theoretical backing as to how it can be successful. And again, some of the theoretical apparatus we've discussed, such as general theory of law and development, tries to shed some light on these questions. James Gardner, another scholar, has discussed that inadequate understanding of multiple roles that the law has in diverse processes of social change and individual choice is a problematic. And Nobuyuki Yasuda, another scholar, mentioned the importance of coordinating regional laws and policies on basis which reflects regional rather than the Western traditions. Brian Tamanaha, I had a privilege to work with him at my previous law school. He's mentioned that one needs to better understand a spectrum of issues faced by developing countries, and again, the local situations, understanding of the local is important. And same conclusion was reached by another scholar such as Maxwell Shibundu in the African context. I mentioned that the second law and development movement focused on neoliberalism, privatization, deregulation. And there was a Washington consensus advocating this position. The Washington consensus refers to a set of policies representing the lowest common denominator of policy advice addressed by Washington-based institutions, and their emphasis have certain commonalities, and they include fiscal discipline, public expenditure priorities towards the areas offering both high economic returns and the potential to improve income distribution, such as healthcare, education, and infrastructure. And tax reform, they favored tax reduction to lower marginal rates and broaden the tax base, interest rate liberalization, a competitive exchange rate determined by the market, trade liberalization, liberalization of inflows foreign direct investments, investment liberalization, privatization, deregulation, and protection of intellectual property rights. But again, these liberalism and liberal policies could not take hold in places where economic advancement and institutional strength were not there to support these policies, right? So, for example, in order to have a strong IPR protection, the country has to have an adequate financial resources and technological basis to protect and support IPRs, which requires a degree of economic development in the first place. The scholars such as Richard Posner advocated the quality of law as compared to quality of institutions and legal structures. Institutions and structures are difficult objectives in the developing countries with weaker the financial and the resource bases. So the Posner would promote having clear, well-articulated laws emphasizing contract and property rights. In contrast, scholars such as Michael Trebilcock and Jing Lang pointed out that informal methods of contract enforcement, so even if you do not have a strong legal enforcement in contracts and property, i.e. weaker rule of law, wasn't really impediment to economic development in its early stages. And if you look at the cases of China, South Korea, and other places where rule of law wasn't really strong, at least from the Western sense, nonetheless, these countries have achieved substantial economic development. Now, Professor Thomas McInerney, again, the director of our Rule of Law for Development program, made an important point that the promotion of rule of law and good governance have unfortunately delivered neither the improved rule of law nor improved governance. And it was important empirical observation. But then the scholars such as Kevin Davis emphasized the importance of legal institutions. In recent years, the international organizations expanded the mandate. So now the WTO played an important role setting regulatory parameters for trade-related development policies. So these are the development in the midst of neoliberalism since the late 80s. In the 80s and 90s, international organizations such as the World Bank continue to support development, with development projects, and IMF, International Monetary Fund, played a role to bail out developing countries in financial distress. The Carol Rose made an interesting point, observing the development of third world countries. And the Rose looked at the China model and mentioned that they incorporated law and development recommendations without causing influence on its politics, so maintaining communist policies and politics. But then again, certain development took place without the changing political apparatus. And then focus on economic development raises a concern that the law and development prescriptions are used without mitigating the adverse impacts of the market economy, including income disparity. But Pister and Su, the Colombian professor Pister and Su, pointed out the lack of adequate government structure and information problem, pointing out difficulty with jump-starting stock markets in transitional economies due to lack of effective legal governance structures and severe information problems. So in those settings, right, not everybody shares the equal amount or a comparable degree of information, and then that created some issues in jump-starting the stock markets, which is very important to develop financially in the economy. And then in some other places like South Korea and Japan, these countries used administrative guidance. We talked about it in our previous class, and administrative governance used informal so these countries used administrative governance in the place of law, where legal development was not strong in the financial sectors. Amy Cha, Yale professor, also made an interesting observation, and she focused on ethnic divisions and development. So finding out that a group favored by market may not be same as the democratic preferences. In other words, an elite minority group can actually prevail in the market where political democratic choice may not have selected them. So there is a gap between democratic preference and actual market control. So which means that if a country focuses on a long-term economic growth, then that might not be led by the group which will be favored by the majority population. So gap between economic elite class and democratic majority, right? Laporta and others, the group called LLSV, promoted the idea of a legal origin theory. So again, I talked briefly about that in our previous discussion. So LLSV promoted the superiority of common law approach versus civil law, and promoted that the common law offers better investor protection, lighter governmental intervention, reducing inefficiency, and promotes independent judiciary. But as we have discussed in the previous class, these features, investor protection, the lighter government intervention, independent judiciary, are not really unique only in the common law system. And some of the most successful developing countries in the past, including Japan, or China, South Korea, Taiwan, they were all based on civil law system, not the common law. And even those countries that had a common law system for development, such as Singapore and Hong Kong, but Singapore had a very strong government engagement in the economy. So LLSV's theory didn't work out as always true if you actually look at the history of development. Another very important development was the recognition of institutional importance. So institutions are important, both under the developmental state, the country that adopts a strong state involvement in the economy, and also under a neoliberal approach that minimizes the state involvement. So in both approaches, institutions are important because if you are applying strong government-led development policies, obviously you have to have institutions that support state involvement. If you, on the other hand, emphasize a private engagement and minimizing state involvement, you also have to have a strong institutions that support private activities, independent judiciary, strong market mechanisms, information disclosure. All these things will have to come in as an institutional support for neoliberal approach. So scholars such as Frank Cross emphasized the importance of legal institutions. But then the question is, which institutions are important? Davis and Trebilcock advocated the quality of institutions. So I've mentioned that Posner, an important jurist in the United States, have argued that it's difficult to develop good quality institutions in developing countries with insufficient resources. So well-announced, articulate, clear laws are much more important. But even if Posner's view is correct that you should have a clear, well-articulated, unambiguous law, again, effectiveness of such a law will be limited unless you have a strong institutional support. So well clarified, articulated laws that grant subsidies, for example, for key industries. If you don't have a strong governmental institution that implement the subsidies under such law, the Posner's clear law may not be effective at all. So you do still have an importance in institutional support. There has been an argument that law has not been very important for the development of East Asia, the region that showed perhaps the most successful development in history. And some arguments are that law has never been important. I think it's misleading. The view is misleading. Their views are based upon the fact that East Asian countries had fewer courts compared to the Western counterparts, fewer lawyers, and legal institutions. However, key economic policies in those countries were adopted in the form of LFIs. So as we will see later in the course, there were strong statutes, the frameworks and institutions, government institutions, were adopted to support the laws that enable the governments to promote experts and industries. So the view in my thoughts were not necessarily reflecting the whole aspects of those policies. Law has that importance in East Asia. Joseph Stiglitz and Sergio Godoy, according to them, the state carried out a vital role of mediating the synergy between the old structures and the new forms necessitated by developments. Every state has old tradition and old institutions, and these states need new structures and laws and practices to facilitate development, and the state mediated between them. I think there's a truth to it, and the successful developing countries in the past have done that. Another scholar, John Onesurich, promoted the importance of studying the legal systems of East Asia in the context of law and development. So, according to a Professor Onesurich, the vastly successful experiences, development experiences in East Asia were not carefully studied, and he brought attention to the importance of studying the legal development, the structural development in East Asia, and we will do some of that later in the course. In recent years, another scholar named Mariana Prado at the University of Toronto has argued an interesting observation, that is institutional bypass. So according to her, it can be useful to create a new institution bypassing the old, because you have institutions doing certain things, and some of the inefficient practices and perhaps corruption and power dynamics were fixated in those structures. So to the point that it's very difficult to change them. So in order to try and change the old structure, Professor Prado would argue that it's sometimes useful to just bypass them and create a new institution with new practices and new effectiveness. So that's probably a better way to foster development. It's an interesting idea, but has limits. The approach may not be adequate for central policymaking. You can't have multiple bodies making central policy. And there is a cost of duplicity in terms of finances and manpower, because now you're maintaining two institutions instead of one. And again, later in the course, we will take a look at the role of pro-development institutions. So additional scholars have promoted the importance of institutions and discussed their inevitable role for development. I'll leave you to the reading in the book. I mean, the book includes additional arguments and scholars. But I will just make one point before I wrap this up. That is, there is no single institutional prescription for economic development. And Idani Rajek of Harvard has made this point. If you look at the thoughts in economics, obviously the institutions that support the free market and free trade have proven to be important. So if you look at advanced countries in the West and in the East, they're all based on market economy. And the communist economic structure has proven to be ineffective. That's the reason why the communist blocs failed. Having said that, the style and kind of institutional prescription adopted by successful developing countries in the past were not identical. So in the advanced countries of today, if you look at the institutions in the United States and Britain and Germany and others, you have a strong and robust private sector players playing a most important role in the economy, and the institutions supportive of such private actions, private economic activities. And based on this, you can argue that promoting rational law, promoting liberty, economic and political liberty, are indeed the cornerstone of economic development. such a prominent scholars as a Max Weber and Frederick Hayek advocated the importance of such a liberal law. On the other hand, if you look at very successful development cases in the past, including South Korea, Taiwan, Singapore, and China, there were substantial control and coordination by the central government in the economy and the institutions that supported such governmental intervention, export promotion policies by the state, number of economic development institutions by the government. They also proved to be very effective and instigated such enormous success. So it's not that a single package is universally effective for all, right? So even if you had a strong institutions that support governmental interventions, it was so back in the 60s through 70s, but in the 80s, even those countries that supported strong governmental involvement in the economy, the focus shifted more towards the private sector through the 80s, and the emphasis has changed in those countries in the 90s and onward. So there has been, even in the case of success, there has been change of institutional focus from state involvement to private sector facilitation. Now, if you look at the countries such as United States, where private economic tradition, private sector has been always robust, the Biden administration has implemented a strong legal provisions, state-led economic development support, mandating tens of billions of dollars in subsidies for semiconductors and electric vehicle development. So again, this also represents a shift of the focus from private sector to state support. It doesn't mean that the economic structure in the US is more state-led rather than private-led, but nonetheless, you see this very strong governmental policy and support facilitated by laws. So the point here is an effective legal and institutional apparatus changes over time depending on the socioeconomic conditions on the ground. So understanding this flexibility is very important to figure out what kind of institutional support that we have to see in order to promote economic and social development. Okay? So the path forward from law and development history. A leading scholar has pointed out three issues. That is, law and development underdeveloped as an academic field, no theoretical framework. So again, the efforts such as the general theory of law and development is a response to this concern that we have to have a robust theory backing up further development of the field. Insufficient case studies. So Honest Search has mentioned that more study has to be done on successful cases in this station. And the third, there is a tension between more state involvement and more laissez-faire regulatory approaches. But as I mentioned, even in places where the state involvement was traditionally strong, such as South Korea and Taiwan, there was a shift, there's a change of focus. And the same also has just taken place in Washington, where the federal government chose to provide tens of billions of dollars of subsidies for the development of semiconductors and electric vehicles. There was a revived optimism there's a cross-country observation of positive relations between legal institutions and economic development. There is no assurance that the rule of law leads to economic development, but it is clear that the laws and institutions have significant impact for economic development and social progress too. And the broader approach, looking at laws and frameworks and institutions as a amalgam instead of separate entities, may be more relevant to figure out the impact of law on development. And the rule of law initiative in the context of sustainable development goals may meet the same fate of failure in the past, first and second movements I mentioned, unless lessons from the past are learned, which means identify the local needs, understand the local socioeconomic conditions, and without them, it'll be difficult to implement law effectively on the ground. Now, this concludes the first part of my lecture on history of law and development. Again, my book includes more information and discussions on this issue. And now we are moving on to the ADM, the Analytical Law and Development Model. So what is the ADM? Now, if you recall our discussion of the general theory of law and development, you will recall regulatory design, right? In order to have effective law, the law should have a strong regulatory design. And the two subcomponents that constitute regulatory design was organization of LFIs and adaptation to socioeconomic conditions. And the ADM is a device that helps us to understand how LFIs should be organized and how laws, adaptation to socioeconomic conditions should be assessed. So the ADM tries to assess optimal LFIs on economic development in the following key areas. Those areas include property rights, contract formation, enforcement, taxation, corporate governance, state industrial promotion, competition, banking and financing, labor, corruption, criminalization of economic offenses, and international rules applicable to trade and investment. In these areas, what ADM tries to do is to assess what optimal LFIs will be to promote economic development. So in each of these areas, LDI is trying to, ADM is trying to identify, based on the empirical studies of successful cases, a set of laws and legal frameworks and institutions, LFIs. What are the effective LFIs and how do we identify them? By studying the past successful cases. What, for example, in South Korea, how they organized laws and frameworks and institutions, right? In Taiwan, for another example, how they would do that. And other places. So we're using empirical studies of actual cases to see and figure out how the successful countries have put together laws and legal frameworks and institutions. And also, ADM aims to assess socioeconomic conditions and variables that are considered essential for the successful operation of the law. And another important aspect of ADM is ADM does not presuppose universally effective. It does not suppose universally effective LFIs and universally important socioeconomic conditions. It presumes that the effective LFIs in each of those areas and important socioeconomic conditions can be different according to the stages of economic development. So, in the 60s through 80s, successful developing countries in the past, such as South Korea and Taiwan, enacted and developed laws and institutions that enable strong governmental intervention and involvement in the economy. But when their economy progressed and achieved a degree of economic development by the 80s, then the government started to change the laws and institutions so that now the more robust private sector could be better involved in the economy, reducing government intervention. So the optimal LFIs and socioeconomic conditions on the ground were different in accordance with the stages of economic development. So again, from empirical analysis of those cases, ADM tries to identify effective LFIs and relevant socioeconomic conditions in different stages of economic development. Okay, so that's the objective and that's the process and approaches of ADM. So the ADM's approach is dynamic, not prescriptive. It's referential, it's not static. So as I've said a few times, the optimal LFIs for economic development can be different in accordance with the stages of economic development. So LFIs that are good for a developing country in the initial stage of economic development may well be different for a developing country going through a different stage of economic development. And I have just referenced the case of Korea. And also the relevant socioeconomic conditions may well be different according to the particular stage of economic development. So Korea's relevant socioeconomic conditions back in the 60s were not the same as the relevant socioeconomic conditions in the 80s, and these differences will have to be identified through empirical study of those cases. So there is a two-step approach again. According to the ADM, the first step is to identify LFIs that facilitate economic development, again, through empirical studies. And the second step is to identify socioeconomic conditions essential for successful implementation. So ADM is both a scholarly enterprise and also diagnostic and implementation tool for specific law reform efforts. So one may use the ADM for academic enterprise and also for pragmatic, practical projects, development projects on the ground. ADM can be used to identify optimal LFIs and to identify relevant socioeconomic conditions in any of the particular legal areas. I exampled the multiple areas where ADM can be applied. So the ADM works as a referential legislative guide, and it's a guide. So the recommendation that can be drawn from ADM is for the decision to be made by the host country. It offers no stipulation or no prescription. It's a guide. And also, ADM can be applicable to promote the economic development of economically depressed regions in advanced countries. So in a rural community in the United States, which is an advanced country, what LFIs should be adopted and what socioeconomic conditions would be relevant to promote development in that economically depressed region within the United States, for example. So ADM is a tool and the rest of the chapter explains the relevant questions one can raise in those different areas. For the interest of time, I'm not going to go through each of those areas in this lecture, but then we will address some of those questions and issues, in the subsequent lectures of this course. So this concludes today's lecture on law and development history and the ADM. So thank you again, and I'll see you again with the next lecture, okay? All right. Bye-bye.